Soy Jorge Lomónaco, representante permanente de México ante el Consejo de Europa. Nos encontramos hoy en el Palacio de Europa, ubicado en Estrasburgo, en Francia, que es sede del Consejo de Europa, para hablar de la relación entre México y ese organismo. ¿Qué es el Consejo de Europa? El Consejo de Europa fue establecido en 1949 como resultado directo de los esfuerzos de pacificación en la región tras las guerras mundiales. Su misión es dar seguimiento y desarrollar estándares regionales sobre tres pilares: derechos humanos, democracia y Estado de Derecho, a través de decisiones, resoluciones y, a la fecha, más de 200 convenciones de cumplimiento obligatorio para sus partes. La primera convención y piedra angular del sistema es la que estableció la Corte Europea de Derechos Humanos, también ubicada en Estrasburgo, de la que todos los miembros del Consejo de Europa son parte y cuyas decisiones y jurisdicción son obligatorias. ¿Cuál es la diferencia con la Unión Europea? Algunos se sorprenderán en saber que el Consejo de Europa precede a la Unión Europea y a todas las instituciones que le antecedieron. Y, a diferencia de la Unión Europea, el Consejo de Europa no es una agrupación de países like-minded, sino un organismo panregional, integrado por miembros con distintos niveles y modelos de desarrollo y con posiciones diversas con respecto a los temas. Incorpora a los países de la Unión Europea, por supuesto, pero también a Europa del Este, el Cáucaso, miembros de EFTA, Rusia y Turquía, es decir, todo el continente con excepción de Bielorrusia. En este contexto, se puede decir que el Consejo de Europa es hasta cierto punto la contraparte europea de la OEA, organismo con el que comparte la diversidad en su membresía, dos pilares, democracia y derechos humanos, la negociación de instrumentos vinculatorios y una Corte de Derechos Humanos. ¿Cuál es el papel de México? La vinculación de México con el Consejo de Europa comienza en las décadas de los 90, a raíz del ingreso de nuestro país a la OCDE y en paralelo al establecimiento de una asociación estratégica con la Unión Europea, a la que seguiría la negociación del Acuerdo de Libre Comercio con la propia Unión Europea. En 1994, legisladores mexicanos participaron por primera vez en una sesión del brazo legislativo del Consejo de Europa, la Asamblea Parlamentaria, aunque sus intervenciones se tenían que limitar a los debates sobre la propia OCDE y el Banco Europeo de Reconstrucción y Desarrollo. Un año después, México participó por primera vez en la Comisión de Venecia. En 1996, iniciaron formalmente las gestiones de México para incorporarse como observador del Consejo de Europa, proceso que culminó el 1 de diciembre de 1999 y que fue resultado de una estrategia gradual de incorporación a diversos comités del Consejo de Europa, incluyendo el de consejeros jurídicos en Derecho Público Internacional, el Cardi, y su admisión, la admisión de México, como observador de la Asamblea Parlamentaria. México comparte el privilegio de haber sido admitido como observador del Consejo de Europa únicamente con otros 4 países. Este estatus es resultado de la creciente convergencia entre nuestro país y Europa en muchos temas de la agenda y del reconocimiento de los valores y principios que compartimos en materia de democracia, derechos humanos y Estado de Derecho. Las poco más de 2 décadas de vinculación con el Consejo de Europa como observador han sido altamente productivas para nuestro país. México ha disfrutado un asiento de primera fila para dar seguimiento a desarrollos en materia de derechos humanos, democracia y otras cuestiones políticas en la región, y ha tenido la oportunidad de participar en un foro privilegiado para la reflexión, la innovación y el intercambio de ideas. Como resultado, México es hoy un activo miembro de la Comisión de Venecia y del Grupo Pompidou y ha firmado 8 y ratificado 7 convenciones y protocolos del Consejo de Europa. En los últimos años, México se ha incorporado a las negociaciones de nuevos instrumentos del Consejo de Europa, a fin de enriquecer las deliberaciones y asegurar que las preocupaciones y aspiraciones de nuestro país queden debidamente reflejadas con miras a eventuales ratificaciones. En esta nueva dinámica destaca la activa participación de nuestro país en la negociación de la Convención sobre delitos relacionados con bienes culturales, la llamada Convención de Nicosia, cuyo resultado fue muy satisfactorio para nuestro país, al grado de que México formó parte del primer grupo de signatarios y es el segundo país en ratificar el instrumento. En el contexto del 20 aniversario de la admisión de México como observador del Consejo de Europa, se llevó a cabo un ejercicio de evaluación de nuestra participación que propició el establecimiento apenas el pasado 7 de octubre de la Asociación Estratégica México-Consejo de Europa, que constituye el primer y hasta ahora único mecanismo de esta naturaleza en el seno del Consejo de Europa. La Asociación Estratégica inaugura una nueva era en las relaciones entre México y el Consejo de Europa y tiene por objeto, entre otras cosas, celebrar de manera regular consultas de alto nivel entre ambas partes, implementar proyectos de cooperación para contribuir a mejorar las acciones en materia de derechos humanos, democracia y Estado de Derecho para facilitar la ratificación de otras convenciones del Consejo de Europa por parte de México y promover conjuntamente las convenciones del Consejo de Europa en América Latina y el Caribe. A continuación, escucharemos a Jörg Polakiewicz, consultor jurídico del Consejo de Europa, quien en su calidad de responsable de Cardi y como responsable también del seguimiento de ratificaciones del sistema de convenciones del Consejo de Europa, nos hará una presentación sobre la labor del Comité de Consultores Jurídicos de Derecho Internacional Público del Consejo de Europa para este 27 Taller de Derecho Internacional. Jörg, además de su trabajo en el Consejo de Europa, es profesor en el Instituto Europeo de la Universidad del Saarre en Saarbrücken, en Alemania, y fue asistente de investigación en el Instituto Max Planck de Derecho Comparado y Derecho Internacional en Heidelberg. Es autor, coautor, coeditor de numerosos artículos y varias obras sobre derecho internacional, europeo y constitucional. Jörg, es un placer tenerte con nosotros. Tienes la palabra.
Muchas gracias, señor embajador, por su amable introducción. Estimado presidente, señoras y señores, es un placer y honor poder participar en la 27 edición del Taller de Derecho Internacional y quiero agradecer al asesor jurídico Alejandro Celorio Alcantara por esta amable invitación. Mi nombre es Jörg Polakiewicz, soy el director del Servicio Jurídico y Derecho Internacional Público del Consejo de Europa. El mandato general de mi dirección incluye lo siguiente: desempeñar las tareas necesarias para que el secretario general pueda cumplir su función de depositario de los tratados del Consejo de Europa. Este año hemos publicado una guía de esta práctica depositar. También proporcionamos una asistencia jurídica a las instituciones del Consejo de Europa, el Comité de Ministros, la Asamblea Parlamentaria, el Tribunal Europeo de Derechos Humanos, y prestamos asesoramiento jurídico también a diversos comités que funcionan en el marco de la organización, sobre todo en la relación con los proyectos de tratados y sus cláusulas finales. Desde mi incorporación al Consejo de Europa en 1993, he trabajado en la reforma constitucional en Europa Oriental y Central, con la Comisión Europea para la Democracia a través del Derecho, la Comisión de Venecia. Fui también encargado del trabajo intergubernamental en materia de derechos humanos, sobre todo la reforma del Tribunal Europeo de Derechos Humanos y las negociaciones sobre la adhesión de la Unión Europea al Convenio Europeo de Derechos Humanos. Fui también secretario del comité establecido por el Convenio de Budapest sobre la ciberdelincuencia y supervisó el lanzamiento de la modernización del Convenio 108 sobre la protección de datos personales. Ambas actividades han hecho un directo lado con el México. En noviembre de 2011 estuve en la Ciudad de México para representar el Consejo en la 33ª Conferencia Internacional de Comisionados de Privacidad y Protección de Datos. Era el IFAI, el Instituto Federal de Acceso a la Información, que organizado esta conferencia. Y para nosotros fue un momento muy importante para la modernización de este convenio. Estoy muy contento que el México ha adherido a este convenio. En octubre de 2014, en Nueva York, participé en la 25ª reunión de asesores legales organizado por el México. E hice una ponencia sobre los sueños se vuelven prácticos, cómo conciliar la aplicación efectiva de la ley y la protección de datos personales. But I will now switch to English for the main presentation, which is an overview of the work of the Committee of Legal Advisors of Public International Law, which is known by its acronym CARDI. I will present you the origin of this committee, the contribution of CARDI to the development of public international law, and also our collaboration with the United Nations, in particular the International Law Commission and the Sixth Committee of the UN General Assembly. The CARDI is a relatively recent creation in the Council of Europe. In 1981, it was set up as a predecessor committee was set up under the name Committee of Experts on Public International Law. But it was in the 1990s, after the fall of the Berlin Wall, that the CARDI became a truly important international actor and also was established under its name in 1991 as Committee of Legal Advisors on Public International Law. The CARDI held its first meeting in April 1991 under the chairmanship of Mr. Helmut Jörg, the Austrian legal advisor at the time, and had the opportunity to welcome as a special guest the Crown Prince of Spain, today King Felipe. This was a particularly interesting moment for issues of international law in Europe because legal advisors had to confront the disintegration of Yugoslavia, the Soviet Union, but also a couple of years later, Czechoslovakia. And the work of the CARDI at this period had particularly discussed all these issues and had come up with common positions in this field. Today the CARDI has brings together the 47 legal advisors of the member states, but also the legal advisors of 5 observer states to the Council of Europe. Besides Mexico, we have Canada, the Holy See, Japan, and the United States of America. We have 4 other observer states: Australia, Belarus, Israel, and New Zealand. And there is also an important number of international governmental organizations that are represented, altogether 10. The European Union, the United Nations, the North Atlantic Treaty Organization, NATO, the OECD, Interpol, the OSCE, the International Committee of the Red Cross, the Hague Conference on Private International Law, the European Organization for Nuclear Research, CERN. And in 2017, it was agreed to grant observer status to the Asian African Legal Consultative Organization, ALCO. What has been the contribution of CARDI to the development of international law? As I mentioned before, I think the main merit of the CARDI is that it brings together the senior legal advisors of almost 60 member states all over the world. And their meetings allow the legal advisors to focus pragmatically on issues that cannot be addressed in the same way within other international organizations. A former UK legal advisor, Sir Daniel Bethlehem, once said, "The world looks different from Geneva than it does from New York." And it certainly looks very different from Strasbourg, where the Cardi mostly holds its meeting. Instead of big power politics, here what is important is the focus on human rights and mutual trust. The Cardi allows the legal advisors to discuss issues that are of common interest and to formulate also common ideas and approaches to the work of the United Nations. As I said in the beginning, a lot of work focused on issues of state succession, and a very concrete result was a book published in 1999 by Brill Nijhoff on the pilot project on state practice regarding state succession and issues of recognition. But the Cardi also played a role in the preparation and the ratification of the Rome Statute of the International Criminal Court. It held altogether 4 consultation meetings on the implication of the ratification of the Rome Statute for domestic legal systems of Council of Europe member states between May 2000 and September 2006. But the Cardi has also prepared a number of soft law instruments, in particular recommendations that have then been addressed by the Committee of Ministers and addressed to the governments of member states. I will just cite a few. There is a recommendation on the depth of diplomatic missions, permanent missions, and diplomatic missions with double accreditation. There is a very important recommendation from 1999 on responses to inadmissible reservations to international treaties, and I will come to this important activity of the Cardi in a few minutes. The Cardi dealt also the recommendation from 2008 on the acceptance of jurisdiction of the International Court of Justice. And in 2008, it prepared a recommendation by the Committee of Ministers to member states on the nomination of international arbitrators and conciliators. The Cardi also regularly holds exchanges on a number of Council of Europe treaties that are within its mandate. This is in particular the 1957 European Convention for the Peaceful Settlement of Disputes and the 1968 Convention on the abolition of legalization of documents executed by diplomatic agents or consular officers. These are relatively old instruments of the Council of Europe, but they still fulfill a very important practical purpose. In this context of treaty making in the Council of Europe, the Cardi has recently been directly involved in a revision of the model final clauses for conventions adopted within the Council of Europe. As you know, the Council of Europe has concluded more than 200 treaties, some of which have become truly international standards. I mentioned already in my introduction the Cybercrime Convention and the Convention on the Protection of Personal Data. But there is also, very importantly, the Convention on Violence Against Women, the Istanbul Convention, or a convention in the criminal law field on the transfer of sentenced persons, and probably the treaty which has been ratified by most countries worldwide in our treaty series is the Convention on Mutual Administrative Assistance in Tax Matters. This is a convention which has been prepared together with the OECD. And in fact, in recent years, there has been a trend to a significant increase in additional and amending protocols because some of our conventions had to be modernized and reviewed. So one of the aspects, which was an important aspect of the work of the revision of the model clauses, was precisely to review and to update the clauses that relate to additional and amending protocols. These model final clauses for conventions, additional protocols, and amending protocols have been adopted formally by the Committee of Ministers on 5 July 2017. Also related to treaty law is what I would call the flagship activity of the Cardi. It is its European Observatory of Reservations to International Treaty. At each of its meetings, the Cardi is presented with a list of reservations and declarations made not only in respect of Council of Europe treaties, but also treaties concluded under the auspices of the United Nations. The Cardi has now carried out this activity for almost 20 years. It is based on the idea, what was expressed at the time in French as a dialogue réservataire. This working method allows states which have formulated a problematic reservation the opportunity to clarify the scope and effect, but also for other delegations to understand the reasons why these reservation declarations have been made, and then taking in full knowledge and informed decision of whether or not to object formally to this reservation. As you know, reservations are a double-edged sword. In some cases, they allow, of course, they are necessary to allow consensus on a certain subject, and member states, the Council of Europe, will only be able to agree on a treaty if a certain number of reservations are possible. But on the other hand, too many reservations may undermine the very purpose of the treaty. So with this practice of reviewing reservations, and also in many cases prompting countries to withdraw reservations that were considered problematic in these exchanges, the Cardi fulfills an important role to uphold the integrity and efficiency of Council of Europe treaties. Finally, I come to my third part of my presentation, which I would like to say a few words about our collaboration with the United Nations, in particular the Sixth Committee of the United Nations General Assembly and the International Law Commission. The Council of Europe is regularly represented in the meetings of the Sixth Committee, and on some occasions we have even been able to prepare side events. For example, in October 2019, together with the Czech Republic, the Ministry of Foreign Affairs, because at the time Petr Valek was the chair of the Cardi, we prepared a side event on Cardi's contribution to international law practice in New York. We also regularly invite representatives of the United Nations, for example, the United Nations Legal Counsel, Mr. Miguel Serpa Soares, attended a meeting in March 2017, and we had also meetings with the President of the International Court of Justice or the President of the International Law Commission. In fact, the annual report that the International Law Commission prepares is a regular item on the agenda of Cardi meetings in September. Only this year we had our meeting in Prague. We had unfortunately no report of the International Law Commission, which could not convene because of the pandemic. A direct fruit of our collaboration with the United Nations is the Declaration on Jurisdictional Immunities of State-Owned Cultural Property. This was an initiative by Austria and the Czech Republic. In fact, it was signed in November 2013 by the foreign ministers of the Czech Republic and of Austria, and it is by nature a non-legally binding document, but which at the same time expresses a common understanding of opinio juris concerning the fundamental rule that certain kind of state property, cultural property on exhibition, enjoys immunity from any measure of constraint, such as attachment, arrest, or execution in another country. By signing up to this declaration, a state recognizes the customary nature of the relevant provisions of the UN Convention on Jurisdictional Immunities of States and Their Property from 2004. This declaration was thus a very pragmatic but also effective way to anticipate the entry into force of this convention and to allow states already to apply a certain number of provisions relating to the immunity of such cultural property on display in another country. So far, the declaration has been signed by 20 states, and the Council of Europe also acts as depository for that declaration. In this context, I would also like to mention that the Cardi Secretariat has submitted observations to the ILC's draft articles on crimes against humanity, which the International Law Commission adopted on first reading in its 69th session. In these observations, we drew on our Council of Europe instruments, in particular the 1974 European Convention on the Non-Applicability of Statutory Limitation to Crimes Against Humanity and War Crimes, but also to a large extent on the rich case law of the European Court of Human Rights in this field. The Cardi's work, I should say, is to a large extent public. There are only a limited number of documents that are restricted or confidential, but most of Cardi's work you can find now in a dedicated database available on the Council of Europe website. And this Cardi database has, for example, covers issues like the immunity of states and international organizations, or the implementation of United Nations Security Council sanctions and respect for human rights. These databases conclude contributions which we have received from the Cardi members, and they usually comprise domestic legislation or relevant case law or other documents. They are thus a very important source of information, not only for practitioners, but also for academia. With this, I've concluded the overview of the Cardi, and I come to my conclusion. The Council of Europe, in fact, these days we are celebrating 70 years of our most important convention, the European Convention on Human Rights. And I think the force of the Council lies in the fact that it does not embody any particular political vision, but draws upon the experiences, skills, and know-how of national experts from member or, as in the case of Mexico, from non-member states. It is perceived as a neutral political actor, in fact, precisely because it is not such an important political force. And this fact gives it legitimacy when it comes to the formulation of legal standards and recommendations, or to the evaluation of compliance with our standards. The Council of Europe's main asset is neither its wealth or its political power, but the credibility and trust acquired through more than 70 years of successful intergovernmental cooperation. The Cardi, with its global and transversal vision of international relations, provides an excellent example of this cooperation. Europe may nowadays count less in terms of population or political and economic power. But in my view, it remains exemplary as a region of the world where international relations are based on the rule of law and an increasingly closely knit web of international conventions and treaties. I would like to thank you for your attention.